Good afternoon, everyone, and welcome to the Committee for Justice's virtual panel discussion on President Biden's competition executive order. I am your host, Ashley Baker, and I'm the Director of Public Policy at the Committee for Justice. I will now introduce our panelists in the order in which they will be speaking. Stephen Cerna is a partner at the Detroit office of the antitrust law boutique of Bona Law PC. He has practiced antitrust law for over 30 years, including more than 20 in-house at General Motors, where he headed up the global competition practice. He is a longtime leader of the ABA antitrust law section and has written for various publications, including the Antitrust Attorney blog. He teaches antitrust law as an adjunct professor at 2 Michigan law schools. Ezrielev Ezrielev is the founder of the economic consulting firm Elevecon. He is a former economic advisor to FTC Chairman Joseph Simon. Ezrielev is an economist specializing in industrial organization, economics, and antitrust policy. At the FTC, Jay helped draft the vertical merger guidelines, worked on the FTC hearings, and also worked on numerous enforcement and policy matters. Prior to coming to the FTC, he was an executive vice president at Compass Lexicon. With 20 years in economic consulting and government, Jay has advised clients on numerous high-profile antitrust matters. He has also taught financial economics at Johns Hopkins University. He has also earned his PhD in economics from New York University. Bilal Sayyed is a senior adjunct fellow at TechFreedom. Bilal was most recently the director of the Office of Policy and Planning at the Federal Trade Commission from 2018 to 2021. The Office of Planning assists the Commission to develop and implement long-range competition and consumer protection policy initiatives and advises staff on cases raising new or complex policy and legal issues. Prior to his time on the Commission, Bilal was an attorney in private practice, representing clients in merger and non-merger matters before the FTC and Department of Justice, and in consumer protection matters before the FTC. Bilal has also taught antitrust law as an adjunct professor at the Antonin Scalia Law School at George Mason University. Bilal was previously an attorney advisor for FTC Chairman Tim Muris from 2001 to 2004. So now, Steve, the floor is yours.
All right, thank you, Ashley. So I want to get the panel started, making sure that all our audience understands what's going on in the executive order, because I think the breadth and depth of the order is rather startling. When it comes to the breadth, so we've got instructions or exhortations, depending on whether we're talking about a department in the executive branch or an independent agency, to the whole of government, including the departments of Treasury, Agriculture, Health and Human Services, Transportation, and then also the Federal Reserve, the FTC, the SEC, the FDIC, the FCC, the FMC, the CFTC, FERC, CFPB, STB, plus a new White House Competition Council, which hasn't gotten in the alphabet soup quite yet. And this is not just about the internet or platform businesses or big tech companies, but it really involves, not just the whole of government, but the whole of the economy. Pharma, hospitals, container shipping, farmers, small farmers, seeds, banks, newspapers, and seemingly extraneous mention of the public health insurance option that doesn't quite fit in, but it's in there anyway. And then also, so this is not just broad, but within each of these areas, there's some very specific and very deep direction for each of these entities. Yes, there are some generalities like the FTC and the Department of Justice should enforce the antitrust laws fairly and vigorously. But there also are suggestions to use examples familiar to antitrust practitioners, review the horizontal merger guidelines and the vertical merger guidelines. And I suspect my fellow panelists will talk about that. Also review the policy statement on standard essential patents and FRAND commitments, and the antitrust guide for HR professionals. And also for those of us who have continued to give advice on Robinson-Patman Lowe these many years, the Agriculture Department is instructed to look at retail concentration and practices to see if they might violate Robinson-Patman. So A&P might be long dead, that Robinson-Patman lives on. Now, maybe this isn't all bad, right? Maybe the executive order can be read as just telling the government to get out of the way. After all, one of the directions is to look at rescinding regulations that create unnecessary barriers to entry. But the executive order goes well beyond that. It explicitly starts from the premise that concentration has been increasing in various industries, and that such increasing concentration is evidence of a reduction in competition. It does not define that or provide evidence for that. It just assumes that those two statements are true. And given those premises, the solution is for the federal government to step in and fix these problems, fix all of these problems, fix all of these problems across the entire economy. So to use former FTC Chairman Olhausen's elegant turn of the phrase, there is no regulatory humility here. Nor does there seem to be any desire to proceed case by case or to test theories in court. I think that's because that would take too long and perhaps the courts would get it wrong. Instead, the executive order talks a lot about rulemaking and other governmental pronouncements. And presumably not that certain practices are wrong and that anything else would be okay, the sort of permissionless innovation that has been so successful here in the United States. But instead, we're from the government, we know what's right, and here's the right way to do things. And given recent FTC actions at its recent open meetings, it looks like we're not going to get bogged down with, say, discussion or debate before we get these new edicts out the door. Now, also, the EO seems like a camel designed by a committee. It's clear that whether talking about the antitrust laws or any of the other laws mentioned, that we're not looking just to protect consumers. We are looking to protect consumers, but it goes beyond that. But exactly who else is not clear. Sometimes the EO talks about workers, businesses, and consumers. Other times it talks about workers, farmers, small businesses, startups, and consumers. Entrepreneurs get a mention. But the difficulty in trying to maximize all these multiple goals comes through in the mention of occupational licensing. So one sentence in the EO says that overly restrictive occupational licensing can impede workers' ability to find jobs and move between states. That seems like a consistent statement with sort of a bipartisan position that's been true for years. But the lead into that statement, in what looks like an obvious rewrite of the original sentence, says that occupational licensing is critical to increasing wages to workers, especially workers of color. So, licensing, are we for it or against it? And if the answer is it depends, what does it depend on? The EO doesn't say, but if we'll soon have to decide based on the licensing effects of various and competing parties, then antitrust truly will become political in the worst sense of the word. Now, in conclusion, I do have some sympathy for the goal of increasing competition by stopping anti-competitive practices. And, that's what the antitrust laws, as currently interpreted, are meant to do. And I will admit that it sometimes seems that businesses are more interested in building moats around their businesses through something other than great products and services that generate consumer loyalty. And so there are bits and pieces of the EO that I could certainly support in principle. It's the rest of it and how I think it's going to be put into practice that concern me. I think that any solution involving thousands of government bureaucrats going beyond the antitrust laws as currently interpreted to tell businesses what to do will be worse than any problem that we have today. So Ashley, let me turn it back over to you and we'll hear what Jay and Bilal have to say.
And with that, Jay, the floor is yours.
Thank you. Thank you, Ashley. It's an honor speaking on such a great and timely panel, and thanks to Committee for Justice for hosting it. I have a few overall big picture comments on President Biden's executive order on promoting competition in the American economy. First, let me say there are some positive things about the executive order that may further the cause of competition. Competition is the engine of growth for the American economy, and promoting competition is a commendable goal. There are some constructive proposals in the executive order. A number of the proposals aim to improve price transparency and transparency of contract terms. Increasing transparency would be a positive for competition. There's also a call for eliminating restrictions on occupational license mobility. Eliminating such restrictions may improve labor mobility and may enhance labor market competition. In addition, there are some proposals to limit there's some proposals to limit regulatory burdens on firms in certain markets. Such proposals may enhance competition. For example, proposals for over-the-counter hearing aid sales are likely to increase competition and reduce prices. The proposals for enhanced portability of data may also be helpful in enhancing competition. However, the executive order also proposes numerous new regulations that would do nothing to enhance competition and may even hinder competition. I would put the main issues with the executive order in two categories: problems and solutions. The executive order lists a number of problems that it argues need to be addressed. These include excessive market concentration and corporate consolidation, rising markups, higher prices for certain items, labor monopsony driving down worker wages, non-compete agreements, dominance of internet platforms, growing income and wealth inequality, and others. However, many of these problems are not problems at all, and even if they are problems that need to be addressed, they're not antitrust problems requiring additional antitrust enforcement. Let's look at the alleged excessive market concentration and corporate consolidation, for example. The executive order appears to conflate the notions of industry concentration and market concentration. The executive order talks about increasing industry consolidation, but what's relevant for competition is competition at the market level. For example, mergers between hospital systems in different parts of the country may increase industry consolidation, but such mergers do not harm competition or increase market concentration because hospital competition is local. And there's also no evidence of widespread rise of market concentration during the recent period. The executive order mentions excessive market concentration as itself being a problem, but excessive relative to what? Is there some appropriate market concentration level? Some markets will sustain only a few firms, while others may sustain more firms. It is important to recognize that increasing market concentration by itself is not a problem. It is perfectly consistent with healthy competition. For example, when a firm innovates and comes up with a better product or service, it may capture a large share of the market. That's a result of competitive conduct, a type of conduct that enhances efficiency and increases economic growth. In this case, increasing concentration is a natural consequence of competition. Some markets may be more efficiently served with a smaller number of firms because of scale economies. Market consolidation may actually make consumers better off. It is not at all clear to me that excessive concentration is a problem that needs to be solved through government intervention. What about labor monopsony and worker wages? There's no evidence of widespread increases in labor monopsony, nor is there compelling reason to believe that lax antitrust enforcement contributed to labor monopsony. There's no evidence to suggest that lax antitrust enforcement led to falling wages. And there's also no compelling evidence that labor monopsony has led to significant wage declines. However, if the antitrust enforcement agencies uncover evidence of increasing monopsony power because of lax enforcement, the agencies have the tools to address such issues. So furthermore, there is no evidence that lax antitrust enforcement has increased income and wealth inequality. Antitrust is not an appropriate tool to address these issues. There are other policies tools for that. The executive order claims that a small number of dominant internet platforms use their power to exclude market entrants. But exclude from what? There is a continual stream of entry by technology firms, incentivized in part by the prospect of acquisition by large incumbents. The executive order suggests that dominant internet platforms maintain their dominance through serial mergers, acquisition of nascent competitors, and the antitrust enforcement agencies regularly challenge nascent competitor acquisitions. And there's no compelling evidence of significant under-enforcement of such acquisitions. In fact, more aggressive challenges of nascent competitor acquisitions may impede entry by technology firms by limiting their exit options. The executive order claims that dominant internet firms gather intimate personal information that they can exploit for their own advantage. This is not an antitrust issue or an issue of lax antitrust enforcement. Users receive valuable services in exchange for providing their information. It's not exactly clear to me what would be the basis for government intervention in these cases if there's no clear disclosure by service providers and if providers protect users' privacy. The executive order suggests that consumers pay too much for broadband and cable television because of lack of adequate competition. It's not clear what it means for competition to be adequate in this context. Nor is it clear that this is an antitrust issue. There's no suggestion that the problem of consumers paying too much for broadband and cable television is a result of lax enforcement or anti-competitive conduct. In sum, the executive order does not clearly identify antitrust problems that require government intervention beyond what the agencies are already doing. In addition, the proposed solutions in the executive order, with some exceptions, would not enhance competition. Rather, the executive order proposes solutions that would increase regulatory burden in many cases, and may actually hinder competition. There are a number of proposals in the executive order that would restrict transactions between private parties and would regulate prices. Here are just a few examples. There's a proposal to regulate early termination fees for end user communication contracts. Such proposals may hinder the ability of service providers to offer promotional initial contracts. Such promotional initial contracts encourage consumers to switch providers, potentially spurring competition. Similarly, net neutrality rules impose additional regulations that may hinder competition. The executive order proposes to limit detention and demurrage charges for maritime shipping. This is price regulation in cases where competition exists. Price regulation does not enhance competition. The proposal to prohibit restrictions by manufacturers on third-party repair would also not further the goal of enhancing competition. This proposal may lead to higher prices for consumers and reduced output. Manufacturers lower prices on goods to induce sales when they know they can earn additional margins from services. The good itself as a loss leader. Reducing their potential earnings from services would likely cause manufacturers to increase prices on the manufactured goods. There are other examples where the proposed solutions would not enhance competition, which I hope to talk about later in this panel. Overall, the executive order encourages the agencies to do what they're already doing. Antitrust enforcement agencies already challenge mergers that they believe to harm competition. The executive order suggests that there's been widespread under-enforcement of mergers, but the suggestion lacks compelling evidentiary support. So I think I will stop here. I'll hand it off to Ashley and Bilal.
Great, thank you. Bilal?
So I think Steve and Jay have touched on a number of topics that I think we've all sort of recognized, and I won't repeat them. I will take a slightly more positive view of this effort. It is not the Biden administration that came up with the idea of sort of a White House council on competition issues. It was an issue discussed in or before the Trump administration took place. And I think in both cases, there was a strong recognition that government gets in the way of competition, either in imposing regulations or in some of the conduct it undertakes itself, like through procurement. So on the whole, nothing has sort of changed yet through this executive order, but it does do something that a number of us in the FTC, and I'm sure the antitrust division, thought was important, right? Which was look to the entry barriers and other regulatory barriers that are created at the federal level or the state level, either through legislation or through what I'll call cabinet level or executive agency departments or independent agencies. So I think that's a very strong positive, right? I don't know much about the Department of Agriculture or the Department of Labor or HHS or Transportation, except I have a strong sense that there's a high level of regulatory capture at these agencies. And, the theory of regulatory capture is, at a maybe high level, that the industries basically are able to protect themselves from new entrants and new forms of competition through, formal or informal processes. So to the extent that this order is directing many agencies to take a hard look at their own conduct, their own rules, their own conduct, I think that is a positive, and it's something that the agency, the FTC especially, but maybe but also the division have focused on for a long time. Some of that has been done, most of that has been done informally, through what I'll call, side discussions with staff at these agencies to say something like, look, what you want to do may be laudable, but the process by which you're going through it or the rules you're putting in place will actually undercut competition. Now, in some cases, of course, we'd also say what you're trying to do is anti-competitive because it's protecting current firms in the market. So to the extent this has become sort of, I'll say, exposed as a serious problem, I see the executive order as a positive. Now, as both Steve and Jay mentioned, there are unsupported, I believe, unsupported assumptions in this order, or weakly supported assumptions or statements. And, some of the language suggests a prescriptive approach that may be unwarranted. But, most of this is report in and then start a rulemaking process. And I think, both of those leave opportunities for sensible policy to prevail. Now, I don't have a lot of confidence in broad-based rulemaking, such as, has been suggested might occur at the Federal Trade Commission. But we know there are already lots of industry-specific rules. And I think, absent removal of those industry-specific rules, improvements to those rules are possible. And if improvements are made with the idea of increasing competition, and I would say mostly by removing entry barriers, I think that's a positive. Now, I'm not sure why, there should be a lot of confidence, or I'm not sure why I should have a lot of confidence that this process, this rulemaking process, won't be captured by incumbent firms. But I think it is good that the White House is thinking broadly across the government about barriers to entry. I think it's a very ambitious proposal. There's a number of report back in 45 days, report back in 120 days, report back in 180 days. Sometimes with the idea of there actually being sort of a published report. At the FTC, we worked on a number of those during the Trump administration, where some other agency was supposed to come up with a report or recommendations in a relatively short period of time. My sense was that led to sort of a rush on work and maybe not strong vetting of some of the work. And of course, many things dragged on longer than that. So I think what they've set out to do is potentially harder. It'll be harder to achieve what they've set out to do. But to keep on a positive note, I think it is a laudable goal to remove, to expand the focus on competition from, just the FTC and DOJ. There's a lot of ways this could go wrong, but at a very high level, I think that's a positive. Jay and Stephen mentioned some of the negatives, the implementation, the underlying assumptions, but this is something I think people at the FTC in particular, and I believe the division, have been supportive of for a long time. That federal government and state government, through executive actions, through legislative actions, and even through administrative actions, get in the way of competition. The people who are leading this effort at the White House, and I think potentially at the antitrust agencies, but particularly at the White House, do seem open to the idea that competition can be increased by changes in entry, by improving access to markets for new firms, innovative firms, and that ought to be applauded, and it ought to be applauded that the council or the leadership of the council recognizes that some of the actions by executive agencies get in the way of innovation and what I'll call future competition. So I wanted to focus on that positive. There are a lot of things in the order that may raise concern, but a focus on this issue is important, I think. So I'll stop there, and maybe we can move to specifics as questions come up.
Sure, Bill, thank you. So I'm going to ask a few questions. We'll engage in a discussion. In the meantime, anyone in the audience is welcome to submit a question via Q&A. Instead of going kind of through those, question by question, I just tend to integrate them into our conversation whenever the topic comes up. So I'll try to get to as many questions as I can. I have a feeling we might have a lot of them. I'm going to start with kind of more of a broader economics question. There's this feeling across the board that greater concentration means more market power. And economics over the past couple of decades have really sort of debunked that. So, the executive order, the fact sheet, for example, it says about it uses rising margins as evidence of declining competition and rising consumer prices. But what do rising margins say about the state of US competition and about the state of antitrust enforcement?
Should I take that?
I think that'd be a good question for you. Yeah.
Okay, great. So that's a great question about the margins, and the executive order fact sheet talks about margins quite a bit. And margins have indeed been increasing, but increasing margins are not at all indicative of weak competition or lax antitrust enforcement. It would be wrong to jump to the conclusion that rising margins necessarily mean less competition or lax enforcement. There are many other more obvious plausible explanations. These include technological change, composition of labor supply, education shifts in US industries, shifts from manufacturing to services, higher returns to innovation and investment in capital. So it's not, and the literature does not really, the economics literature does not really support the conclusion that rising margins are the result of less competition. Moreover, it is not clear to me that rising margins are a problem themselves. It's like arguing that the rising stock market is a problem. Firms increase profits when they become more efficient or when they engage in innovation and succeed. For firms return profits to investors, I don't see rising margins as a problem that needs to be solved.
Any further commentary on that? No. Let's get back to the idea, some of the ideas surrounding the FTC. I think that's really important. In the executive order, it calls for, or it suggests, because FTC is an independent agency, that the FTC engage in rulemaking process. But at the same time, we've seen over the past 2 meetings by the FTC, which have been both in July, these supposedly open meetings, in which they're clearly moving in the direction of Section 5 rulemaking. What do you see as being kind of that interplay? How are they moving, in the direction of rulemaking, and what is that going to look like? And also, should they do it?
Let me start, but then I'm really interested in Bilal's take on that question. So again, perhaps I'm going to say that the glass is half empty, and my friend Bilal will say that it's half full. But it does concern me. Not so much that we've got open meetings. That's wonderful. I think the transparency is great. What is concerning to me is the I don't know, speed, lack of deliberation, lack of discussion, lack of debate on a number of what seem to be important issues. There's certainly issues where there are 2 sides, at least 2 sides that could be discussed. That's what I fear will happen going forward, because I agree with you that the EO does seem to be pushing more towards rulemaking and less towards, for instance, filing new lawsuits and seeing what happens in either the federal courts or even the administrative court at the FTC. If we were talking about a rulemaking or a similar procedure that would be more deliberative than what we've seen in the last month, I think I'd be a little more sanguine about it. But again, perhaps my friend Bilal can make me feel better about it.
Well, I'm not sure I can make you feel better, except to say, some of what the agency has done in the last month, or roughly last month, has been to remove some guidance documents. They weren't rules. They were guidance documents. Now, I think those guidance documents were proper and right, but they were not rules. To the extent the agency will do rulemaking, either on the competition side or on the consumer protection side, there are processes they have to go through, and if they don't go through them, that will be a problem under the APA or other specific statutory requirements. So while I don't think rulemaking on the scale that some have suggested is a good idea, I do take some comfort in the fact that that is a process that the courts will have some oversight of, and impose some discipline on not only the process, but also the substance of what is considered. Now, I'm no administrative law expert, But I do understand that the agencies in rulemaking have to take account of the comments received in the process. And, on any of these topics that I've heard folks, discuss there may be potential FTC action, there are going to be, views expressed on both sides of the issue. And it will not be simple for the agency or any agency to disregard the well thought out, well supported, well considered views of participants in the rulemaking process. So, I have my doubts about whether rules are appropriate, particularly on the competition side. I have my doubts, strong doubts, that the agency has the rulemaking authority it thinks it has on the competition side. But my bigger one concern is that this will be a wasted 3.5 years where the agency focuses on rulemaking to the detriment of thoughtful guidance or thoughtful case selection, and that at the end of the 3.5 years, maybe for good or for bad, they will not have achieved much. That, I think, is true of what happened with the rulemaking effort and the dominant firm case effort of the 1970s at the FTC. And I think that's the path they're headed here. And I think that would be a lost opportunity. I mean, I have broad statements about whether there's enough competition, not enough competition are useless, I think, to an antitrust lawyer or someone who might practice in the regulatory field. But there are areas where better enforcement, faster enforcement, more thoughtful enforcement, and or policies, including guidance, would have a positive influence. It's something that I think the Commission has tried to do over time. There's continuity between administrations, but I think often an attempt to build on the work of previous administrations, or even maybe make some corrections to efforts by previous administrations. What seems to be going on here, both through the actions of evidenced in these open meetings and in the writings of some of the people at or influencing the agencies, is a real desire to throw out what's happened over the last 20 to 40 years and return to something that I think many people thought failed, which was the rulemaking and large case effort of the 1970s. So I worked for Chairman Simons most recently. Joe believed, change was necessary. We didn't do all that we wanted, but I think he was right. Changes in practices at the agencies are necessary. But I think what they're doing is really going to be a lost 3.5 years. And that I think is a shame, and it reflects, a desire to just throw out, sort of the good work of the last 40 years, and also move away from what I'd call sort of the, step-by-step approach to improvements. And I just think, putting aside whether it's good or bad, I just think good or bad, what they want to do. I think it's just the wrong way to make improvements, and it's going to be a waste of their time there.
So I have a question here from the audience. I think this would probably be a good one for Steve. And it says, Biden's concept of non-compete agreements is extremely problematic for small, innovative companies. Will he exempt those companies that need to protect their trade secrets?
Yeah, and certainly, to directly answer the question, the answer is I don't know, because it's certainly not clear. It does seem that the EO thinks that non-compete provisions are bad. But exactly when they are bad, how bad they are, it is not clear. Even under today's antitrust laws, the non-compete provisions, can go too far. If we're talking about a business that is investing in its workers, the training of its workers, is sharing trade secrets, with its workers, then certainly a non-compete for some period of time, perhaps limited in scope as well, would seem to be appropriate under the antitrust laws. But perhaps a non-compete in, say, the fast food industry could be an issue. And again, some of those non-compete lawsuits that we've seen, the private lawsuits that we've seen, have raised horizontal issues or hub and spoke issues, where you've had a franchisor imposing those kinds of non-competes on its franchisees who are competing with each other. And so the question is whether we've got a horizontal agreement, not just a vertical agreement. But I think the main point is that those non-compete provisions can be good for competition, can incentivize investment in workers, and can be good for the overall economy, and that today's antitrust laws evaluate those, I think, on an appropriate basis. Calling them out in the EO seems to indicate that they would want to change that interpretation, perhaps to restrict their uses. I think perhaps going too far, but it's not clear. And certainly the specific question of whether there would be some sort of carve out for small businesses, there's no detail in the EO that would answer that question.
Ashley, I'd like to just say one or two things here. Chairman Simons was very interested in a rule on non-compete agreements. And, we spent a lot of time thinking about what that rule might look like and how it could address the potential complexities, that were raised. So I'll give you an example. There was a talk about, banning non-competes for low-wage workers. Well, somebody made the point, I think it's a good point, that, hairdressers, hairstylists, barbers, are relatively low-wage workers, but they develop sort of a personal following that is in some way attributed to, the business, the efforts by the business to give them space. Now, when those people move to another location, should they be able to appropriate all, of sort of the goodwill that's developed between them and a particular client or not? And if they are, how does that affect the willingness of, the shop owner to bring a, individual on? So I'm not saying I know the right answer there, but even for low-wage workers, these are complex questions. I will though say also that some of the concerns that have been expressed, such as the concern about trade secret protection, can be protected in other ways, right? So, we had a workshop or conference on this, and I think it was Orly Lobel who said, look, think about what the business is trying to protect, and think about whether there is a narrower way to protect it, right? And that's not a bad, at least thought experiment. And if non-competes are used too broadly, maybe there's a basis for trying to narrow the scope of what individuals are prevented from doing, when they move from one job to another. Again, all this strikes me as complex and potentially articulated through a rulemaking process. Now, I will say that I have some strong doubts as to whether the agency is the right place to do a labor-related rule, in part because it's not clear to me they have rulemaking authority of this type, but also because this really is a rule that goes to labor mobility. There's probably some interplay between other terms of employment. And it seems to me the Department of Labor might be the better place to think about this issue, maybe with input from the commission staff or the antitrust division. But it certainly doesn't seem right to me that the antitrust agencies, which really don't know much about labor markets, would be the right place to do this.
So I agree with Bilal that this is not really an antitrust issue. And certainly there are both costs and benefits on non-competes. And potentially there may be some rulemaking that's helpful and valuable. But I want to go back to your question about rulemaking and what the FTC is doing. And also related to non-competes. It seems that on non-competes, they've already made up their mind. And on rulemaking, there seems to be a rush to judgment that we need solutions. We need to do rulemaking before first identifying what the problem is. And non-competes, let's identify what the problem is, and then see how rulemaking may help. On other issues that the FTC may be considering, rulemaking on, it's a rush to judgment. It's putting a cart before the horse. Let's figure out first if there's a problem. If there's a problem that needs a solution. And if rulemaking may be the way to address the problem. Starting off with rulemaking as a solution seems to put things in the wrong order.
I have a question here. One of my favorite topics that's in the EO but shouldn't be in the EO says big tech has helped make patents worthless. Patents are the only way small companies can compete. What will Biden do to help small inventive companies get strong patents? Let me put that in a broader framework, not so specific. So in the EO, it kind of takes aim specifically at standard essential patents, particularly at biopharmaceutical patents, and it asked the DOJ, particularly not the FTC, just the DOJ, because they were on the opposite sides of this issue, to reevaluate their views on the intersection of intellectual property and antitrust. Where do you think they'll go with that?
Well, maybe I can start with a high-level comment. I think it's particularly bad that as administrations change, the approach to IP and antitrust issues change, right? Put aside who has the better of the argument. The fact that this, may now flip again strikes me as a problem and a suggestion that, people aren't thinking about, sort of a longer run approach here. The commission, I think, has been largely constant over the last 20 years in how it deals with IP and antitrust issues, although it was during the Simons administration relatively quiet on that. Way back when, in the early part of this century, the commission took a position that there were limitations on what the PTO was doing, and that some thought should be given to whether patents were being granted, inappropriately or without sufficient basis. And so in a sense that flips the commenter's question on its head. Firms deserve patent protection. There's a benefit to it. But again, we should be careful that we're not protecting things that are obvious just because somebody gets the patent office with a complex filing. So again, more thought ought to be given to, how strong, how many patents should be granted, or under what conditions a patent should be granted. Because while again, protection of intellectual property is a spur to innovation, of course, it may also decrease entry. So again, it's this balance, and what we've not seen, I think, in the last decade is a recognition by different administrations that there are two sides to this question, and that certainty and continuity probably matter, right? And that small changes are probably smarter than broad policy pronouncements that switch. And we found that the agency, at least within OPP, that some of these questions may turn on industry-specific facts. They have different effects in different industries. Doesn't mean you have sector-specific law or rules, but that you think harder about the benefits and costs of what you're doing. So that doesn't directly answer the question, but I think it's a real shame, I think, that there's a lot of flipping on this question, particularly solely at the Department of Justice and and its sort of counterparts in Commerce, PTO, and the like.
So I have a question. Is the mention of the Robinson Patent Act and increased enforcement a good thing or a bad thing? Will it trigger some modernization of the RPA? And the question would like to add that she asked that, hopefully.
Well, as I said, for those of us who never gave up on Robinson Patman, who continue to advise on Robinson Patman, continue to write on Robinson Patman, geez, it's full employment work. That's great. I don't think that I would envision changes in the way the Robinson Patman is written. That could be helpful. I do think that if we're talking about the same way that the Robinson Patman has been written and has been interpreted over the last, say, 20 or 30 years, I think that this will be again, to use Bilal's phrase, sort of a waste of 3.5 years, because I think it's going to be very difficult to bring a successful Robinson Patman claim, given the court interpretations that we have. But I will say that I do not think it is impossible to do that, and that there can be claims brought even under the current interpretations of the Robinson Patman Act. It just depends. The facts have got to be very specific and have to hit the terms exactly right. I don't know whether that's a good thing or a bad thing. Perhaps Jay will be willing to comment on that. But I do think that it will be quite a change in the way that the antitrust laws in general have been interpreted over the last 20 years, if we go back to a time when we've got an awful lot of RP cases.
So it was a little bit jarring to see the mention of Robertson Patman Act in an executive order that seeks to promote competition. It's not a law that is particularly helpful in enhancing competition. It's not clear that the executive order doesn't really make a clear case for why we need more enforcement of Robertson Patman Act. What is the need? What is the rationale? Have we been missing it all these years? And there's just it goes along with sort of the regulatory theme of the executive order and potential for some mischief and harm.
So we have
Oh, go ahead. Ashley.
one really quick question. Oh, sorry. Go ahead.
No, go ahead. Let's move off.
Okay, as I said, we have time for only one really quick question. We have some panelists who need to hop on a 2 p.m. call. And this one is about this is indeed with like some more discussion on the FTC's authority to promulgate competition rules and the possible legal issues there.
Well, okay, this is something Steve may have thoughts on too. This is something we looked at in OPP when thinking about, a rule on non-competes. It's something the agency, I think, maybe looked at, or when they were thinking about rules with respect to pharmaceutical pricing or pharmaceutical products. There's a case out there from the 70s that suggests to some people that the agency has competition rulemaking authority. I mean, the case does seem to take that position, although I think it's a more complicated position than the way I articulated it. But administrative law has changed in the last 40, 50 years. And, when I was director of OPP, because of Joe's interest in this question, we asked internally, what is our belief in the strength of this position? And I never got a very convincing answer, that the commission staff, including OPP staff, had really thought through the likelihood that appellate courts and eventually probably the Supreme Court would agree with the view expressed in National Petroleum Refiners. So this is just an area where I think there is a high possibility of just wasted time by the agency. There is a lot less deference given to agencies now than 50 years ago, and it just raises all. I mean, they just simply may not have the authority to do a competition-based rule, particularly where the agency has failed to find any cases, that would fit into the type of rule they're considering for non-compete agreements, labor-based non-compete agreements. Internally, we basically said, if we think we can write a rule, why can't we find a case that we could bring, or series of cases we could bring, to provide support for us moving forward with a rule. And nobody had a very good answer. The state cases, settlements, a fairly low number of complaints that touch on this issue, look a lot like consumer protection cases, not the type of consumer protection cases the agencies bring or the FTC brings, with some, ambiguity on whether it's sort of a competition issue or not. So this is just an area where, I think more thought really needs to be given on the authority, and also, how they would identify the problem, and given that, I think they would be in a rough road in the courts if they do promulgate a rule.
I agree, and thank you. And I'd like to thank all of our panelists. Apologize for ending 1 minute early. I know some of you have to jump off to a call. Quick shout out for a group a coalition that I now run. It's called the Alliance on Antitrust. I encourage you to go to allianceonantitrust.org, and you'll find the video for this is in addition to a lot of FTC comments and other work that I've been doing. And thank you all for attending today.
Thank you. It's fun.